it is correct. We got the expedited trial date because the widow was sick, but she tragically passed away in September.
Okay, go ahead and state your appearances.
Good morning, Your Honor. Eric Pepperman for Plaintiffs.
Good morning.
Good morning, Your Honor. Dan Polsenberg and Jim Cavanaugh for ETT1 doing business as Terrible Herbst.
Good morning, Your Honor. Karen Bashor on behalf of Nevada Beverage.
Good morning, Your Honor. Brad Johnson, Jake Bowie on behalf of Benedict.
Good morning. So, do you want to talk first about the jury questionnaire or the motion to stay?
I think the jury questionnaire would probably be better, Your Honor, since we're already on. These guys aren't.
Okay.
No, we were on the same day. I don't think Brad was there that day. That's why he doesn't remember.
I don't want one to be shorter than the other one, Your Honor. I want you to be pooped out by the time.
Well, yeah, I mean,
I would suspect you're pooped out already, Judge.
There's been a lot of pro per stuff, whatever the court
I
wants.
was sitting with co-counsel going, inchoate? What does inchoate mean?
What's your preference, Your Honor?
You're the judge.
The good news is, my jury from before is now deliberating, so. In any event, yeah, let's talk about, the jury questionnaire. Players say, well, nearly identical, essentially the same. That always begs a question to me is, what does nearly and what does essentially mean exactly? Everybody agrees we need one. There's a few issues that parties disagree, I suppose, on the language. Welcome, Plaintiffs' Counsel first.
Okay, Your Honor, thank you. And I'll start by answering your question. Nearly the same is, there's been some slight modifications in each of the cases in response to, different language changes proposed by the defendants in the next case, or additional questions that the other defendants may want to add. But those have been just minor changes. The length and the substance of the questions have all been the same. Many of the questions that they dispute have been in there from the beginning. They were in the questionnaire used in this case that Real Water in that case stipulated to. Because we've used substantially the same questionnaire and subject to these minor modifications, which, by the way, if you read our reply, there's several that we agree to in this case, that minor language changes that they've requested that we've acquiesced to and don't have a problem with. Similarly, if they had questions they wanted to add, information they wanted, that wouldn't be a problem. The problem is they want to basically say, oh, we don't want to ask all these pertinent questions because the questionnaire is too long. There's really no support for that. I mean, we've used the same length of questionnaire in the prior cases. We have empirical information from those cases that show that these are effective and beneficial.
Let me ask you if I can, apologies for interrupting. Which ones is it your understanding are still in dispute, other than the overall length, which I did read this stuff, although it was last week, and I don't remember really the overall length being a real issue, but maybe it still is. But in terms of what specific ones is it your understanding are still in dispute?
Well, it's a lot, Your Honor. We can go through each one if you want. They're outlined in our reply, starting on page 4. And so we have multiple defendants, Nevada Beverage and Terrible Herbst. They don't object to many of the questions that Real Water objects to, but they start with question 3. They want to remove the question about what media the potential jurors were exposed to. We disagree with that. Question 4, ask whether there's anything that might affect a juror's ability to be fair and impartial. They want to remove some of the responses. We have a, check the box response following question 4 that gives reasons that allows the jury to check. That has provided invaluable information on potential biases to evaluate both before voir dire and, during the voir dire process. Question 6. They want to remove the question, do you believe that you could be fair and impartial as a juror in a lawsuit brought by the plaintiffs against various defendants related to the manufacture, distribution, and or sale of real water? Question 11, they want to remove the question of whether the juror has the capacity to listen to the court's instruction not to read the news.
I'm gonna interrupt you again, I apologize. But, so yeah, looking through your reply, I guess, let me modify my question maybe. Because to back up a little bit, it seems like there's an awful lot of these questions that, kind of as I think you pointed out, one group of defendants are okay with, the others not, and vice versa. Just skimming through your reply. Maybe to narrow it down, are there any, and if you're not, I'll ask them the same question when it's their turn. Are there any that both sets of defendants object to?
There are a couple, and Your Honor, I apologize, I have to,
That's okay.
the first sentence of each one, we say whether Nevada
I
Beverage.
think it looks to me like almost all of them. I mean, but I could be wrong. So let's go ahead and hear from them, because
Yes, Your Honor, I think whatever their specific concerns are, I'm happy to address, but just from plaintiff's perspective, this is all informational. It's not a benefit to either party. We each get it. It's shown in the past that it makes voir dire more efficient, that none of these questions are overly prejudicial. They've been to the benefit of both parties, and we have the empirical evidence from the past 5 trials to bear that out. So the request to exclude so many of the questions is just not well founded. We ask that they be all given as they were before.
thank you very much.
How are you doing?
Good.
Jacob Suty, bar number 16330 on behalf of the real water defendants. So the primary issue here, Your Honor, and I'm going to try to keep this short and sweet just because that's what we want from our jury questionnaires, for it to be short and sweet. I'm sure we've all seen the point, when the jurors' eyes kind of start to glaze over, when things are just overly burdensome, overly encumbering on them, and it starts to lose the point of why we do the jury questionnaire, which is to help expedite voir dire and ensure that we can impanel a jury that doesn't have any significant biases to either party and is able to follow the law and your instructions that you give them. And so the suggestions that we have on the jury questionnaire are to help expedite the process and ensure that the main questions that fulfill that goal still happen. A lot of the questions that they still want to include in, for example, are pop psychology type questions that you could see in like the back of a magazine, for example, your favorite television shows, do you consider yourself describing yourself, like, are you witty, are you funny, like stuff like that doesn't necessarily show if someone's actually going to be biased or not. And it's mainly done as a way to be able to help build a Facebook, if you will, of jurors that they think might be more inclined to give them a larger verdict than actually jurors that are going to be able to follow the rules and obey the law. And the last thing we want is to be burning the jurors out on questions like that when we have more important questions to be addressed. There's plenty of instances, and I believe even on the last trials, where the jury questionnaires were going unfinished or unanswered. So by simplifying the process, it helps ensure that the quality questions and that quality jurors can get impaneled. Footnote 1 of the reply, for example, recognizes and they adopt 22 modifications that we had proposed and 4 deletions. That's 26 changes out of 114 questions. That's 23% of the jury questionnaire they're willing to actually agree to change now. And then more importantly, Your Honor, their jury questionnaire that was originally submitted was 30 pages. Ours is 19. So that's an almost 40% reduction. It's going to help get the jurors in, get the jurors out, make sure the jurors have the opportunity to appreciate the questions that are being asked of them, and to make sure that we're not overburdening jury services as well, or the members of the community when they're being faced with questions that aren't really applicable to the matter as much.
So I'll ask you the same question. Which questions are you aware of that both defendant teams object to?
And that's a fair question, Your Honor, and I'm not gonna try to put words in Nevada Beverage's mouth, so to speak, but in reading their reply, I think the main gist of it is that they're requesting that you order for there to be a meet and confer for the parties to be able to redline and work together to create a jury questionnaire versus them doing a longer list of line item questions that we were objecting to. And again, I don't want to be mistaken what they have to say if they want to come up and say that, but I think, that all the parties agree at this point that changes need to happen. They're already adopting a significant amount of what we're proposing, and we just want to make sure everyone's on the same team in the sense we want a jury questionnaire. It's just we want to make sure it's the most effective jury questionnaire.
Thank you.
Good morning, Your Honor. So in an effort to streamline this for everyone, I did review Real Water's proposed jury questionnaire, and in hopes of resolving this, I'm on board with their streamlined proposed questionnaire. So if Your Honor wants to go ahead and adopt that, I think that would make a lot of other potential issues moot. In the event Your Honor does not want to adopt the Real Water proposed questionnaire wholesale, there were a number of individual jury questions that I objected to and proposed changes for. I can address those specifically unless Your Honor is willing to move forward with Real Water's proposed questionnaire.
In all candor, what I think I'm gonna do is say something and have you meet and confer after I say something. That's
Okay.
probably what I'm gonna do. And I cut you off like I did everybody else, but do you have anything further?
No, Your Honor, I would just say that based upon plaintiff counsel's reply and our review for Real Water's questionnaire, if the Real Water questionnaire is not adopted wholesale, then I do have issues. The remaining issues would be with questions 48, 49, 46 in part, and 111.
Thank you.
Thank you.
Hey, and is that all the defendant's side, right?
Yes, Your
Okay.
Honor.
Yes, Your Honor, we're ETT one,
Oh,
General Purposes.
I thought there were 3, but yeah.
No,
go
we're
ahead.
informed with Ms. Bashor's comments for the other defendants.
Okay. Plaintiffs.
Like I mentioned, that their argument is just the questionnaire is too long. And they're missing the point. They didn't say one time there was a question in the questionnaire that is not an appropriate question to ask during the voir dire process. So it's not like they're saying that we're asking things that are improper or inappropriate, nor could they, or we wouldn't otherwise be able to ask the jurors. The purpose of the questionnaire is to give all parties advance information to allow them to adequately prepare for voir dire, so we could limit the number of people we brought in. We can stipulate to excusals. We can follow up on questions rather than asking them for the first time in court. It makes the process more efficient. It's worked in each of the prior 5 trials. It's shown that we've gone in. I think the most we've brought in was 2, maybe partially part of a third panel. So we've been able to get the jurors from the first 1 or 2 panels that we brought in, which is a tremendous efficiency, as you know, Your Honor. And then that doesn't even speak to the critical importance of a right to full and fair voir dire. It's not just biases, there are peremptory challenges that we are entitled to ask questions of the jurors for the purposes of fully and fairly exercising those peremptory challenges. And it's the same for the defendants. I don't understand why they want less information in the questionnaire process. It gives us, it's not like we only get the information, everyone gets it. They get it for their purposes too. They can make their voir dire more efficient. They can follow up. We can ensure that if there's when we're talking about trial number 6, there's a tremendous history. If you get one person who says, oh yeah, I was exposed to the media, I read about this verdict in the paper, that's a problem. And these types of questions are designed to get at that in the questionnaire so we can bring them in individually, so they're not saying things potentially infective of the rest of the panel in front of the panel. It makes no sense to just say, oh, well, we think this is going to be too tiresome to the jurors, especially when there's been no problems whatsoever in the prior 5 times we've used a substantially similar questionnaire. So, Your Honor, we've agreed to work with them within reason on language issues and that sort of thing. And if Your Honor's inclination is to meet and confer on those issues, we'll of course honor that request and do so in good faith. But their main thing here is to try to cut for some reason that is really not clear or explained. And I would firmly request that the jury questionnaires be allowed, subject to any, further meet confer on the language of particular questions.
Thank you. So, you're gonna court orders you to meet and confer further in good faith and work on any of the language. However, I do agree with plaintiff's argument in terms of the overall length of 30 pages. That's fine. Being thorough is better upfront. And when one of the defendants talked about, well, plaintiffs just want this particular information for whatever reason, before Mr. Pepperman even argued, my thought was, well, everybody's going to get the information. So, whether somebody puts down something that plaintiff likes or whether somebody puts down something that defense likes, you're all going to have the same information. That goes back to, being thorough up front is perfectly reasonable. Some of the questions, if you're asking about plaintiff, should track better about defendant. But in terms of the overall length, it's totally fine. We do need to, get this done. I'm just looking at a docket. Looks like you'll all be in front of me on December 3rd. That might be a little further out than I'd want you to do this process and get this finalized. And for me, if there's any remaining disputes, obviously I would need to decide. Want to come see me on next Monday. And again, I know you're in front of me on December 3rd, but thoughts on coming back in front of me on the jury question?
Sorry, said, Your Honor, you said the 24th?
Yeah, that would be next Monday.
Yes, Your Honor, the 24th would be fine with plaintiffs. If that works, or if, depending on what the remaining disputes are, if we can't agree, I don't know if there's.
That could be
guidance
moved
in
if
writing.
could be moved if you all agree, but anything from defense side?
On behalf of the real water defendants, that should work. It's next Monday should work for us.
That's fine, Your Honor.
24th is fine, Your Honor.
Okay. So yeah, in the meantime, good faith meet confer, 30 pages is fine. I'd rather you be thorough up front than not. I think that's been shown to be clear in others of these trials as well. So next Monday.
That'll be November 24th at 9 a.m.
And anybody's welcome to, after your effort, give me something that I can look at and make decisions on whatever else is in dispute. Okay. ETT and Nevada Beverages motion for stay. Is that the other thing we have on?
That is exactly right.
Okay. So I've reviewed the motion for stay, plaintiff's opposition.
And we didn't get a reply. So let me see how quickly I can go through this. Well, although I think Mr. Pepperman might agree that more is better. So
Probably depends on more of what.
true that. So Rule 8C lays out the factors that a court should consider in ruling on an injunction or a stay of proceedings pending a writ petition. And there are 4 factors. One is whether the object of the petition would be destroyed without a stay. 2 and 3 are the balancing of the fairness, and 4, it goes to the merits of the case. So here we clearly have, if we don't get a stay and we have to go to trial before the Supreme Court can hear the writ petition, it would destroy the object of the writ petition, because what we want to do is not have to go to this trial linked with 4-year-old older cases and have to go very quickly. And when I briefly argued this the other day, Mr. Kemp said, oh, no, the Cavanaugh case, Khiabeani, is a case that did go to trial in less than a year. So Exhibit B to our motion is the motion to expedite the trial in Khiabeani. There, the lead plaintiff, Dr. Barron, Barin, who was the widow, the executrix, and the guardian of the 2 sons, had stage 4 cancer and wasn't going to live 6 months. And that was the reason for such an expedited trial. But if you look at the published opinion in that case, they say in their opposition, Supreme Court affirmed, but you can see that there was an issue. I didn't raise it as an issue having to do with the expedited trial. I only raised it as having to do with one element of damages. There was newly discovered evidence in that case that we didn't find out until after the trial, that Dr. Khiabeani had been audited by UNLV Medical during the acquisition of the UNR medical procedures, and that there were some serious questions, as the opinion says. Now, I'm only arguing from public documents. My brief in that case was redacted, so I'm only looking at the published opinion. There were accusations from Channel 8 about Medicare fraud. So So that would have gone to several issues, one of which would have been the amount of damages for future financial support. So I don't want to be in the same position here where we're pushing this case on a very tight deadline. And I'll tell you the truth, the Cavanaugh
Well,
case.
that's always good.
There you go. You know, Judge Israel always points out that I say that. It's, and I usually say when I'm about to say something harsh. I had real suspicions after Cavanaugh, and my spider sense is tingling here, that we were trying to push the Herbst case so quickly when there's no reason to push it. At least in Cavanaugh, there was a medical reason for an expedited trial. Here, there isn't any, and we're just grouping it with older cases to get it to trial soon. So let's go to the balance of the hardships. The hardship to ETT and Nevada Beverage. Yes, we have to hurriedly go through the discovery, especially on causation and damages. The issue that was raised in Cavanaugh that wasn't fully explored. And I think it's improper to do it here. The harm to the real parties in interest, it would just be that they have to try the case. And forgive me for putting a sharp point on it, try it fairly. And the fourth factor is the merits of the appeal. So they lead with that, of course, because unfortunately the language of 8C is the likelihood of success on appeal. But the Nevada Supreme Court has made clear in Micon versus Gaming that if the object of the appeal will be destroyed, you still look to the merits of the appeal just to make sure it isn't some frivolous petition. The federal courts don't look to the merits. If the object of the appeal would be destroyed, they grant stays. Here we look to see whether they're bona fides. And I do have legitimate reasons to seek this writ petition. And so I think under Micon Gaming and Hansen says you don't have to prove you would win. You know, I used to argue this all the time with Judge Gonzalez, about whom I can speak now since she's not a judge. And I'd say, look, I'm never going to convince you you were wrong. And she agreed that I didn't have to. I just have to show I'm raising a legitimate issue. So you look at all those factors, and we should be able to get a stay here. So when we were here last week, plaintiffs kept arguing severance, and I was confused why they were arguing severance. Is this really a severance issue? Severance to me seems to be a more Rule 14 issue, a Rule 21 issue. But then I found out over the weekend that the Nevada Supreme Court, in another real water case where my friends on the other side represented the real parties in interest, that the Supreme Court did issue a writ petition on November 4th and did instruct Judge Williams that he had abused his discretion in not severing out third-party claims there under Rule 14 and not severing under Rule 21. And they said that the court needs to look at the ACAB, 2 words, ACAB versus Murray factors. And some of those factors, look at that. It's the same things that we've been talking about all along. Whether the claims arise out of the same transaction or occurrence. Well, I get it. It's real water. Real water isn't the one asking for the relief that I'm asking for. The questions here are different. The causation questions are different. The damages questions are different. ETT, and oddly enough, this other case is the Ohio Security Insurance Company versus 8th Judicial District Court. That arises out of the Gallagher case. We're not, ETT1 is not in any other cases. We don't have the same, they can't make the arguments of economies of scale here that we are going through the same thing that real water is going through. So I think it's inappropriate here we've said deconsolidate. The Nevada Court of Appeals used deconsolidate once to say that when you aren't consolidating a case anymore, you deconsolidate it. And that's in O'Connell versus Wynn, footnote 1. We could call it separate trials under Rule 42B. I think I wasn't counsel record when we made the motion to deconsolidate, but I think that aptly describes what this court should do. So looking at all the circumstances, we ask for a stay so that we can run a writ petition. Thank you, Ron.
Thank you. Before you sit down, you mentioned, and maybe it was in here, maybe it wasn't. If it was, I certainly didn't see it, but you talked about that other real water case, where the opinion or the ruling was on November 4.
Yes, it was an unpublished decision. It's case
Hold on, sorry. I'm writing unpublished right now. What's the case number?
89926.
89926. Okay, thank you.
Thank you, Your Honor.
Anything from anybody else on that side before we turn it over to plaintiff's counsel?
Yes, Your Honor, just real quickly, in addition to the fact that the timeline, the expedited timeline, as well as the consolidation would be unduly prejudicial to Nevada Beverage as well as Terrible. In addition to the outstanding depositions that remain beyond this week, beyond close of discovery, there still remains Nevada Beverage's motion to compel. We still do not have a reply from plaintiff as to that, nor do we have a date from the special master as to that motion. And again, we are, we basically been put on notice that counsel as well as our experts need to be educated and well versed as to the medical history of the other plaintiffs as well as other non-parties to this trial, past and present. I also wanted to emphasize the fact that in light of the jury questionnaire issue, on top of hurrying to prepare for trial and trying to digest, analyze, and be properly prepared for that trial, we will now have to review approximately 500 to 600 jury questionnaires between 15,000 and 18,000 pages and be able to form a strategy around that within this time frame as well. So based upon those reasons, Your Honor, we request a stay.
Thank you.
Your Honor, Jim Cavanaugh for ETT1, DBA Terrible Herbst. I would just add again, there's absolutely no discernible prejudice to the plaintiffs, for the other plaintiffs in the Shaparov, Martinez, Rick matter for the deconsolidation and a stay for Herbst. And there's in fact, in reality, no prejudice to plaintiffs' counsel. They have 2 other wrongful death matters that have been filed this past summer, and there's no prejudice at all to granting the stay for the non-real water defendants. Thank you.
Thank you. Okay.
Your Honor, first, few things. First, the writ in the Judge Williams case, the Gallagher case, that has absolutely nothing to do with the issues before this court. That was an issue related to Rule 14 and the third-party practice. In Gallagher, the plaintiffs had acquired an interest in third-party claims that were pending in that case. They amended the third-party complaint to add the Gallagher plaintiffs, who then asserted third-party claims of their own against Liberty. The issue there on severance was, can the third-party plaintiffs assert the third-party claims against Liberty in that same third-party complaint when it didn't seek damages that a third-party plaintiff would have been liable to the plaintiffs for. It was a very intricate, strange legal issue, and the court said, no, it shouldn't be part of that third-party complaint. It should be, severed as a separate complaint. It had nothing to do with consolidation or continuance, which this court has already twice ruled has granted consolidation. First initially, and then last week when it denied the motion to continue and deconsolidate. And that's really what this is. I mean, this is really effectively an improper motion for reconsideration of that ruling. There's no writ petition that has been filed. There's no, they're just asking for a stay. It's essentially, you should have granted the motion to continue, which would have granted us a stay of the trial effectively. It's a totally improper motion for reconsideration. The request for stay, it's really, the written motion contains no facts and is light on detail. It relies on length of time alone, which the court addressed last week as proper. And I will reiterate that in light of the Rule 8 factors. And especially with Cavanaugh, if you recall, Your Honor, that came up because Mr. Polsenberg stood up and said, in my 40 years plus of practice, I haven't had a wrongful death case go to trial in less than a year. And Mr. Kemp rightly pointed out that the Cavanaugh case did go to trial in much less than a year. I tried that case with Mr. Kemp and Mr. Christiansen and remember it well. That case, it is correct. We got the expedited trial date because the widow was sick, but she tragically passed away in September of 2017. Once she passed away, there was no issue with the trial date. We still had the trial in February. It was less than 9 months from the date we filed the complaint. And the facts of this case are much different because we did not have the coordinated discovery in that case. And that was the heart of this court's initial ruling to consolidate and the order denying consolidation was, look, discovery hasn't been going on for 6 months in this case. It's been going on for years. And Nevada Beverage and Terrible Herbst has been part of that discovery. They've been part of multiple trials. Even though they settled out before the trial, the discovery
I was going to ask, I think you answered my question maybe when you modified a bit. I know both of them have participated, generally speaking, in the cases, but have either of them actually gone to trial?
Terrible Herbst in the Hunwardson case started trial, gave opening statements, started with witnesses, and settled during the trial. Nevada Beverage has not actually gone to start a trial, but the settlements with them have been well after the close of discovery, well after pretrial motions have been filed. So they have participated in the coordinated discovery. They have had the benefit of all that fact discovery in multiple cases. And in this case, just like the others, the case-specific discovery is related to plaintiffs' specific causation and damages. And on that issue, they were first provided the Herbst records, his medical records, more than 7 months ago. In March 2025, they had nearly all of them by April or May time period. They've had full and robust opportunity to do discovery in this case. They have disclosed experts. They have filed motions for summary judgment.
So, sorry, I thought I had formulated the question already, but I had not. Bear with me a second. So one of the arguments they make, and several of the other ones I'm not sure are persuasive, and this one I'm not sure is either, but maybe. They say, well, back in when I first did the consolidation, there was this representation from your side of, hey, one of the reasons is, you know, we essentially don't have, and I'm paraphrasing inartfully so, but essentially we don't have other cases, you know, and it'd be a huge burden on us to try the Hearst case all by itself. What defendants are saying now is, well, there actually are now, maybe not back when we did the consolidation, but there are now, at least according to them, 2 other wrongful death cases. So one, is that true? And what's the status of those other ones? And why not say, well, I still think consolidation was right, but let's stay this to see if I'm right or not.
Well,
That's a lot of questions. One, I apologize.
yes, Your Honor. So recently we have filed 2 new cases. The Soteros case, which is a wrongful death case, and the Jaster case, which Mr. Jaster, we allege he died from ALS, and we allege that he consumed real water, which was a cause of his ALS. Those I cannot speak. I believe we've received some answers with respect to the Soteros complaint. I'm not sure about the Jaster complaint. I can't be sure. But they have been filed, and that is true recently, and they are in their very early stages. I don't think that those have really anything to do with this issue, because we don't know what is going to come, or I can't predict the future on those cases. There is a lot of moving parts in litigation proceedings related to real water and you know, the insurance coverage and bankruptcy proceedings, and so there is nothing that anyone can say that is certain with respect to how those cases are going to proceed or what's going to happen in those cases. What we can say is certain is it still makes the most absolute sense that these cases were consolidated, because we have completed discovery. Discovery closes technically on Wednesday, Your Honor, but subject to a few lingering depositions.
I knew there was a modifier coming there.
Yeah, that we are
we have
accommodating.
almost, there's some other modifier completed. Right.
Your Honor, any discovery that is not going to be complete by Wednesday is an accommodation to the defendant so that they can have no complaints regarding the opportunity to depose all the witnesses they wanted to depose, or to accommodate the schedule of their witness. Other than that, discovery is going to be finished on Wednesday. This is on the same track as the other cases in terms of you finish discovery, you file the motions, you prepare for trial. We've done it 6 times before. They've had more than 7 months of case-specific discovery with respect to Milo Hearst. They have not identified a single thing that justifies a continuance or stay, or however they want to, you know, describe it to reach their ends of avoiding trial, except for the chemotherapy. And
I think you already blew that out of the water.
Exactly.
Candidly, I mean,
they've just, you know, let it go. You know, they don't even make that argument anymore. Now it's on to something else. It's if you look at the Rule 8 factors, any defeat of whether the object of the petition is likely to be defeated, that's their own creation. They delayed noticing all these depositions until the very end so they can say, oh, look at all these depositions. They had the information for 7 months. They could have deposed these doctors. They did not. They can't create their own reason for saying, hey, well, the object of our appeal will be defeated by our own conduct. And the prejudice, there's no prejudice to them. They've been in the case, they've been doing discovery, they have their experts, we're all done. There's no prejudice that they've identified. The only thing was chemotherapy, which they've abandoned. The prejudice to us is severe. We've prepared our case to go to trial. We have all our experts. We've invested substantial amounts of money preparing the case for trial. The resources of these trials, as Mr. Kemp said, are extensive. And for the court too, Your Honor knows that. There's no reason for the court to have to expend its resources doing another trial based on a stay for a writ petition that they haven't filed from an order that was clearly a proper exercise of discretion, which gets to the last factor, which Mr. Polsenberg minimizes this, but it's the most important one. They're not likely to prevail on the merits of this. We cite in the opposition extensively that this is a matter of the court's discretion. You exercised it correctly. It's highly unlikely that there's going to be any intervention in this. The vast majority of discovery has been done as part of the coordinated cases that they were a part of. They've had plenty of time on the narrow plaintiff-specific Herbst discovery, many months, in line with the same amount of time as in the other cases and the other plaintiffs. The Chiabani case is proof positive that it can be done. And it's not an issue. And we specifically cite the Nevada Beverage's prior retention of the same expert that they have in this case.
I read your opposition was thorough and detailed.
And we'd submit on that. And Your Honor, I'd ask that you don't allow them this reconsideration. If they want to file their writ petition, they've made their motion to stay here. If the Supreme Court thinks there's any legitimate reason to stay, which I cannot.
No, I know you disagree. Thank you.
Thank you.
You're right, Judge. I do disagree. So let me take the last couple of factors first. They come in and say the merits of the forthcoming appeal is the most important. No. The Nevada Supreme Court has said that the object of the appeal is the most important. The federal courts have said that that factor is so important, it eclipses the merits of the appeal. The Nevada Supreme Court says you still have to look to the merits to make sure it's not frivolous. But the most important one was, would it destroy the object of my appeal? Yes, if you make me to go to trial first quarter of next year without a stay, then my writ petition is all for naught. They argue again, it's in your discretion. Yeah. Well, severance was in Judge Williams' discretion in the Gallagher case, but the Supreme Court still said it was an abuse of discretion not to sever there. They say Chiabani proves it can be done. I think Chiabani proves that it wasn't done right in that case. We were forced by circumstances to do it as quickly as possible, and there are circumstances that don't exist here.
So some pushback on that, though, is, is detailed in plaintiff's opposition. This case, these cases, plural, really, it's not like your clients coming in brand new. There have been multiple other cases with all sorts of discovery, all sorts of trials. So how does that not play in the plaintiff's favor in terms of, unlike maybe Chiabani, which I assume was like some one-off normal kind of case here, even though your client may not have gone to trial or fully gone to trial. It's aware of numerous of these issues and the experts and all that. Doesn't that favor plaintiffs?
No, because the case, they are saying they're general issues and that they're case-specific issues. The problem in Kiabani were case-specific issues, causation and damages. I'm gonna rely on Mr. Cavanaugh because I've been, what's this, Monday? I've been in this case less than a week, but we don't have purchase records. There are medical causation issues. You can't even say all the science has been resolved, that we're just looking at accounting. There are a lot of case-specific issues that aren't resolved here and aren't resolved by the other cases. So I think it is like Kiabani. The only difference is in Kiabani, there was a legitimate reason for the court to say, we're going to trial in 6 months and to give 5 months for discovery. There isn't here. This is bolstering. You're trying to get a new case in with some 4-year-old cases and try to accelerate it and give limited due process in this case, when there are, we now know, 2 more cases newer that we could consolidate Hearst with. Am I asking for reconsideration? Well, I think I'm right, but.
Well, so to quote a former judge that's already been referred to, I think one of the things that she would say often is, until the judgment's final, it's not final.
Yeah, I agree. And the license plate on my Jeep was 54B, and that's what 54B says. You can consider it anytime up until the final judgment. And yeah, that particular former judge, you may know, was the best man at my wedding. So I'm sure she reconsidered some things. So, and they keep, so am I asking for a stay? I'm asking for a stay. That's what I have to do now. They say I haven't filed the writ petition yet. I don't have to file the writ petition to ask for a stay. But as I made clear to you last week, I have to ask you, because when I run the writ petition, I'm going to ask them for a stay right then.
Do you have the case numbers from those other 2 cases? Or if anybody else does, the other 2 real water and
Solteros.
yeah. Well, you can keep arguing. Somebody hopefully on that side will find them.
I've never heard you say that. I was going to stop.
Well, why I said that is I was afraid I'd cut you off.
No, that's good. I think I've covered the highlights. Thank you.
Thank you.
Your Honor, just briefly then too, not sure quite where to start. There were comments that we've waited. On November 5th, plaintiff noticed Tim Herbst's deposition without ever talking to me or finding out any clarity of my schedule, so the only date between November 5th and a 14-day notice to set it, which they set, and along with 3 other former employees from November 19th, which happens to be a day we have several doctors, plus plaintiff's primary medical causation expert, Dr. Jeffrey Kahn, gastroenterologist, who they've never disclosed before in any of the prior cases. And by the way, there's been, what, 28, 29, 30 of these real water cases.
One's Kahn's depot?
The 19th.
Okay. Oh, I see what you're saying.
Yeah.
I didn't
And
quite
after we
follow
had,
you.
yeah, and after we had discussed and settled on the 19th as the day to take the primary plaintiff's expert's deposition. We're looking to work with plaintiff's counsel to move it out if they need to depose Mr. Herbst. I have no control over those 3 former employees though. But there are a lot of differences between a wrongful death case in this case that we're being consolidated in with. But even very fundamental differences in the products even. As your honor is aware, there's a difference between home and office delivery product. right?
You raised that, I think, in.
Okay, and that's those other consolidated nine plaintiffs. Hearst is not a home office delivery case by any means. What we've said before, and we would hope a jury would hear it, there is absolutely no testimony that Mr. Hearst ever purchased real water from Terrible Herbst, number one. And no testimony when he ever drank real water purchased from Terrible Herbst. No testimony that he ever consumed real water purchased from Terrible Herbst. Yet we'd be in a trial and they're going to hear plenty of evidence that 9 other folks did, and terrible, and it's such a horrible product. And we're, whether we, the relatives say, well, he told us summer before he passed away, this was his favorite water. And nobody, there's been something like 10 family and friends of Mr. Hearst. None of them could, most of them didn't know what real water was or what it even looked like. So they honestly said, we can't tell you he ever drank it. We never saw him drink it. But
so you got a minute more, I guess.
The prior cases, the Terrible Herbst has been 2 prior cases. One of them, they started trial in before we became counsel. There were stipulations and issues that prevented, my understanding, prior counsel even litigating causation or medical injury. Those were transplant cases. They weren't wrongful death cases. And they're right. They were settled. But we have different experts. They have different experts. We have different parties. Neither Terrible's or Nevada Beverage was in this case. And then 2 new cases. The Sotero's case where counsel's looking up for Nevada Beverage. That Steve Sotero's died 4 or 5 months before Mr. Hearst died. And it's got to ring somewhere importantly to this court. This case should never have been jammed into this kind of schedule. And I don't think the court knew, nobody knew how much additional records and all these other facts, and the court couldn't have anticipated we'd be here at this point, 45 days or whatever it is before trial, trying to do depositions of an expert we had never heard of before this case, who's their primary medical causation expert, and his deposition's yet to occur. And the fairness of this, there is no fairness to make us go into a trial with these kind of different claims as a different defendant without having been in a case with these other plaintiffs who've been in here 4 years. There's no prejudice to plaintiffs. That's the key thing here. How could there be? They represented to the court, it cost $500 and something thousand to try one of these cases. And this is our last real water case. I believe that was an actual representation. I'm not sure there's any dispute of that. And that's not true. It's not the last real water case. And the other ones they have are death cases. If there's somewhere we should be consolidated, it perhaps would be there.
Thank you.
Thank you, Your Honor. No prejudice to plaintiff.
Yes, Your Honor. Just real briefly, Nevada Beverage has never been to trial. Based upon the prior verdicts in the 5 other cases that have been tried, there are billions in exposure. And there is nothing about the common discovery that has been conducted to date that will alleviate either the expedited timeline upon which we are forced to try and prepare for trial, nor number 2, the consolidation and bolstering and the prejudice that would incur. And that was not even a factor in the Cavanaugh case. The Cavanaugh case that has been addressed only addressed the issue as to the expedited timeline. We are being forced to deal with number 1, an expedited timeline with unfinished discovery, and number 2, the prejudice from bolstering. And there is nothing, again, about the common issues or common discovery that will alleviate any of that prejudice. Second, with respect to the liability, that is not finished. That liability discovery is not finished. There is a lot that remains outstanding with respect to our motion to compel. Again, the special master asked plaintiff to respond to our latest letter indicating that we still do not have what we need. There is still 11,000 pages of receipts that are redacted. We do not have a response. We do not have a hearing from the special master as to that liability discovery on top of everything else that remains. Further, as to the plaintiff specific discovery, Your Honor is well aware of the outstanding experts. And again, this is not a very simple, well, alcohol in the alternative causation issue. This is alcohol plus. There is discussion, numerous questions about hydrolysine, slow versus fast acetylators. This is complicated stuff. We're trying to learn as we are trying to be prepared for each deposition day after day after day. We don't even have time to digest and figure out what we need to further investigate, analyze, or talk to our experts about. Based upon the concerns raised by Mr. Polsenberg as to this, the spidey senses about what potential issues, this is what makes me, I can't sleep at night, Your Honor. I'm worried about what we might be missing here. And this is significant stuff, especially considering the exposure involved. With respect to the other plaintiffs, we've talked about that. And then I also want to address this issue of alleged delay, because counsel seems to be relying on that in the papers and as well as oral argument. There was no delay. And that also highlights the fact that we need to pay attention and be given time to address continuing litigation and be able to pivot accordingly. One of the reasons those additional medical providers were not requested for deposition until the time that they were was because it was in response to plaintiffs' change in strategy to start seeking depositions of other lay witnesses to try and impeach the medical records about continuous alcohol consumption. So in response to that, we had to act accordingly. We don't have a chance to even barely have a chance to review the transcripts and make any necessary changes and pivots in our strategy to deal with that, Your Honor. So again, I believe that highlights all the reasons that a stay should be imposed.
Thank you. Did anybody find those other two case numbers?
Yes, Your Honor, I have,
Okay.
Soteros is A25-927-579B.
Sorry, say that again.
A25-927-579B.
Okay,
We are not involved in the other one.
I have Jaster, Your Honor.
okay,
Jaster is A25-928-221B.
okay. So I'm gonna look at, the internet wasn't working very well. I finally pulled it up, but I didn't even get a skim at, the order in the unpublished case. I'm also gonna look at those other Suteros, or however you say in Jaster. I gotta tell you, I'm probably still not gonna grant the motion, but I wanna be thorough. Take a look at those. And let's put in chambers for me, so that I don't forget, a week from today.
That'll be November 24th in the court's chambers calendar.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, is there anything else on the calendar today? It's my understanding
Yes.
there's gonna be a trial readiness, back in the
Yes.
day, determined that we'll be ready to go for trial on a date that the court was
Status
inclined to
check.
begin this.
Yes. Status check, Your Honor. We would need a hearing date for the motions in limine. I don't have that on my calendar here, and a reply deadline as well.
Nor am I,
Are you coming back on Monday in front of me?
Your Honor.
Yeah, cause as I sit here, I have no idea what you're talking about.
Trial date really is what I was looking for.
Trial date?
Yeah, I didn't know if this January 20th date was the date they were going, or that's been firmed up, or.
Yeah, so. I got nothing for you right now.
No problem.
Talk to, if you need clarification on something, first talk to plaintiffs, if you want, hey, judge hears this issue, file something brief and I can take a look at it before. Right here. Next Monday.
So are we set to come back on the
I
24th?
think so, didn't
Yeah.
No?
We
just
said, we just said.
I thought we just said it.
Questionnaire.
Yeah, on the questionnaire.
Oh, possibly. That could have
Didn't
been
we?
someone.
Me, confirm to
Okay,
come
yeah,
back.
yeah, so come see me next Monday.
And that
Yeah.
would,
So then we'll adjust the hearing, Your Honor, for the motions eliminate that time? And reply
I
deadline?
mean, I can't even answer that question.
Well, thank you, Your
All
Honor.
right, thank
Sorry.
you. We'll talk to you next week.
appreciate
Thank
you
you very
guys.
much, Your Honor. Have a good day.